Hello, I'm Nick Hopkins. I'm the Law Commissioner for Property, Family and Trust Law at the Law Commission of England and Wales. Before I was appointed to the Commission, I had a career as an academic, and I'm also a Professor of Law at Reading University. Land law has been an important part of my work, both as an academic and as a Law Commissioner. It's a subject that captured my interest at a very early stage, and a key influence in this respect is a book by Graham Symes called Real Property and Real People. What the book demonstrates is that land law is about people as much as it is about land. We describe property law as a law that governs the relationship between people and things, and land, as a branch of property law, as a law that governs the relationship between people and land. But when learning landlords' rules, which can appear complex and abstract, it can be easy to lose sight of the other and more important side of the equation, people. And so my contribution to the series of lectures, I want to focus on people. And I want to focus on how one aspect of law, long residential leases, has impacted on people's experience of that most important part of land, our homes. I'm sure you all know a bit about the Law Commission and have probably read some of our consultation papers and reports, not only in land law, but in other aspects of your studies. We were set up in 1965 and given the job to keep under review all of the law of England and Wales and make recommendations for reform to government. We often describe our role as being to make the law fair, modern, simple and cost effective. We make our recommendations for reform through consultation. And so in a law reform project, we prepare a consultation paper with provisional conclusions, and we prepare that through researching the law and through talking to people about their law. We then hold a full public consultation in which we invite people to give us their views on those provisional conclusions, and we analyse those responses to make our final recommendations. We publish those recommendations in a report, and our reports are often, but not always, accompanied by a draft bill drawn up by parliamentary drafters who are seconded to us and who we work closely with. Now, consultation lies at the very heart of what we do, and the heart of the consultation process is talking to people who are most directly affected by the law under review to gain a real understanding of the impact the law has on their everyday lives. Every 3 to 4 years after a public consultation, we agree with government what areas of law we'll look at next, and we publish that in a programme of law reform. We then agree terms of reference for each project with government. Now, importantly, having agreed our projects and terms of reference, we work independently from government in making our recommendations for law reform. Our current programme, the 13th, was published in December 2017, and it includes within it a project on residential leasehold and commonhold. Now, in fact, that consists of 3 projects, a project on enfranchisement, on right to manage and on commonhold. These may be quite unfamiliar aspects of the law with you, but I'll explain a bit about them in this lecture. But also, I want to think about the importance that these areas of law have to those affected by them. So don't worry if you don't really know much about these areas of law. In brief, enfranchisement is a body of law that gives people who have a long lease of their home certain rights either to extend their lease or to buy the freehold. Sometimes the freehold is bought individually. For example, the leaseholder of a house can buy the freehold of their house. Other times, the right to buy the freehold has to be exercised collectively. So leaseholders of flats in a block, for example, can get together and collectively buy the freehold of their block. Now, when they exercise those rights, leaseholders have to pay for the extended lease or for the freehold. They have to pay a premium or a price to their landlord. The right to manage is a right given to leaseholders in a block of flats collectively to take over the management of that block without buying the freehold. So it's a little bit like a collective freehold acquisition, but rather than taking both the ownership of the freehold and with it the management of that freehold, the leaseholders take only the management, leaving the freehold title as being owned by their landlord. And then common hold is a different way of owning flats. It's a body of law that allows flats to be owned on a freehold basis. I'll say more about common hold later. But as I say, don't worry too much about those areas of law, because this lecture is more about the impact that law has on individuals than on the details of those areas of law themselves. So how does this work relate to the home? But by this stage in your studies, you'll know that legal title to land is owned through two estates: the freehold estate that lasts forever and leasehold estates that last for a fixed period of time. You can listen to Judge Elizabeth Cook talk about those estates in another lecture in this series. So when somebody owns their home, they own it either by owning the freehold title or by owning a long lease. So a lease granted, for example, for 99 or 125 years, or sometimes much longer, such as 999 years. Our projects are about those who own their home through leasehold and about an alternative way of enabling people to own their homes. What many leaseholders have told us is that they do not feel that they own their homes at all, a sense that's echoed in empirical research previously undertaken into leasehold ownership, which summarised leaseholders' experience as being that of owners yet tenants, a phrase that captured the sense that while people were told they had bought their home and they owned their home, they felt that in many ways the law treated them in the same way as it treated renters. Now, to understand why home ownership is important and what it means, we have to put the law slightly to one side and focus again on people. Fulfilling the dream of becoming a homeowner has long been the ambition of the majority of people in Britain. It's a dream that's been nurtured and encouraged by successive governments since around the beginning of the last century. So in 1910, only around 10% of people own their homes. Currently, around 65% of people own their homes, and home ownership levels have peaked before at over 70%. Buying a home rather than renting is seen as bringing with it a number of benefits. Some of those benefits are financial, so ownership of the value can be seen as lying at the core of home ownership and has been seen as a defining characteristic that separates the owner from the renter. Home ownership is promoted as a means of accumulating wealth, with the home increasing in value over time, as giving the homeowner an asset that can be used, for example, to secure borrowings, as an inheritance to be passed on, or to fund their older age. It's an insurance against the risks and uncertainties of life, and essentially it's seen as a financially sound means of paying for a roof over your head. But the home is about much more than just money. In her book called Conceptualizing Home, Professor Lorna Fox describes the so-called X-factor values that home ownership encompasses and that have become embedded in an ideology of home ownership. These values include security and stability and autonomy and control, amongst a range of perceived benefits. Now, the law that governs how people own their home is crucial in how the benefits of home ownership are experienced, and many leaseholders we've spoken to have highlighted that leasehold ownership does not provide them either with the financial security or with the X-factor benefits that they're expected to have as homeowners. As regards the financial benefits, in leasehold, the financial investment in an asset in the home is split between the leaseholder and the freeholder. The lease itself is a wasting asset. From the time it's granted, the clock is ticking down, and at some point either the lease comes to an end and the home has to be given back to the landlord, or the leaseholder has to exercise an enfranchisement right to extend the lease or to buy the freehold. For landlords, the property is fundamentally about money, both the capital value in the freehold and other income that's generated. So, for example, the income received when enfranchisement rights are exercised and the premium or price is paid. So in essence, what leasehold does is put the financial value of the home in the landlord's hands to some extent at the expense of the leaseholder, a division that isn't found in freehold. As regards the non-financial benefits of the wide range of so-called X-factor values of home ownership, I'll just say a bit about the two I mentioned earlier, security and stability, and autonomy and control. So as regards security and stability, it's often claimed that home ownership offers greater security and stability than renting. Home ownership provides a sense of place and permanence. In practical terms, owning the home may be the only means of providing long-term security to stay in the home. People who rent in the private sector often have short-term tenancies, perhaps granted for 6 months or a year in the first instance. The social renter sector has now been described as providing only a fragile safety net. Now, of course, security isn't absolute. And as Lord Diplock reminded us, the ability to stay in an owned home can be dependent on the ability to pay the mortgage for that home. He described Britain not so much as a nation of homeowners, but a nation in which that we have a real property mortgage to a building society democracy. But for leaseholders, there are additional risks, including the risk that the lease would be forfeited. Forfeiture is a right that landlords can have to bring a lease to an end if the tenant is in default. And if a lease is forfeited, not only is the home lost, but the landlord is also entitled to keep any money that's left after debts and fees have been discharged. In a more general sense, leaseholders can feel less secure in their homes than freeholders because of the relationship they have with the landlord, because their estate doesn't last forever. As regards autonomy and control, another of the perceived advantages of ownership is a sense of independence and control that owners enjoy. As an owner, you can choose how to enjoy the property, how to maintain it, how to improve it, when and how to dispose of it. You can modernise and personalise your home. So in the 1980s, for example, a right was introduced called the right to buy, a right that enabled leaseholders of council homes to buy their home. Now, one of the phenomenons that was noticed around that time is that when people bought their home, they would often change the front door. That changing of the door from a standard door provided by their council to a personally chosen door was seen in a very real sense as marking their transition from an owner, marking their transition from a renter to an owner. So how does our work help? Well, we've made recommendations to change the law so that it works for people who are most directly affected by it. I said earlier that we agree terms of reference for our projects, and for our work on residential leasehold and commonhold, we agreed that we would seek to provide a better deal for leaseholders as consumers, and that we would increase transparency and fairness in the market. Now, what's notable about these terms of reference is that they are not neutral. They represent a task of changing the law so that it works much better for leaseholders, and a decision government had made that we should make recommendations to change the law in that direction. We see our recommendations for reform as designed to ensure that the law that governs home ownership is fit for purpose, and that there are two separate but equally important strands to achieving this aim. The first is to improve how the law works for homeowners who continue to own their home through a long lease. So, for example, when leaseholders exercise their enfranchisement right to extend their lease at the moment, they receive an extension of 90 years in the case of a flat or 50 years in the case of a house. We recommend that the extension should be for 990 years, so that leaseholders have a much greater sense of security, and so that the financial value of the home is placed in leaseholders' hands. The longer the lease, the more the financial value shifts in the lease rather than in the freehold. The other strand of our work is about enabling more people to own their home through freehold rather than leasehold. And we achieve that in our recommendations designed to reinvigorate common hold. And so common hold is a final topic I want to talk about in this lecture. As I explained earlier, people who own their home do so either by holding a freehold estate that lasts forever or a leasehold that lasts for a fixed period of time. I've explained how leaseholders fail to give people the benefits that they expect to enjoy as homeowners. So why then is leasehold used to deliver home ownership? Well, in England and Wales, most houses are owned freehold, but that's not always the case. And in recent years, there was an increase in a number of new homes or new houses that were sold on a leasehold basis. But government has announced that it will ban the sale of houses on a leasehold basis, save in some exceptional cases where the leasehold is considered to perform a useful function. So once that ban has been introduced, nearly all houses will be owned as freehold in future. Flats are almost always owned as leasehold, and that's for two reasons. If you own a flat, how you maintain it is going to impact on other flats in the block. So in very simple terms, for example, your floor is another flat's ceiling and your ceiling is another flat's floor. So the law needs to be able to impose positive obligations on flat owners, for example, to keep their flat in repair. Positive obligations or positive covenants that are contained in a lease remain enforceable against a new buyer when the lease is sold. But a positive obligation or a positive covenant contained in a freehold title is not generally enforceable against a new buyer when the freehold is sold. Now you'll learn more about that when you look at the rule in Tolkien Moxey in the law governing restrictive covenants in your land law course. So leases are used as a means of owning flats so that positive covenants are enforceable in the flats. The second reason that leases are used is to put in place a management structure for the block so that all of the common parts of a block, such as the stairs, the lifts, the corridor, as well as common parts on a wider estate, such as car parks and grounds, are managed properly. As the owner of those common parts, the landlord is responsible for the management of them and often will appoint professional managers to undertake that task on a day-to-day basis. But leasehold was not designed to provide a management structure for blocks of flats. It has been adapted to do so. And it is not used in most other parts of the world. Most other countries have specific schemes in place for the ownership and management of flats, which enable individual flats to be held on a freehold rather than a leasehold basis. For example, schemes known as strata and condominium title are commonly used elsewhere. In England and Wales, the equivalent scheme is called common hold. So what is common hold? Common hold is not a new estate and it is not a third estate. Common hold is essentially a form of freehold. Its full name is a freehold estate in common hold. Common hold is a bespoke scheme designed to provide a management structure for flats and other interdependent units. In a common hold block, each flat is owned on a freehold basis, not leasehold, so that flat owners have an estate that lasts forever. The common parts, so the parts that in a leasehold block would be owned by the landlord, are instead owned by a company called the Common Hold Association. Each of the flat owners is a member of the Common Hold Association, and so the flat owners collectively manage their block and their wider estate through the Common Hold Association. Now, just as a landlord may appoint professionals to manage the block or estate, so the unit owners may and indeed probably will do so. Each common hold has a rule book called the Common Hold Community Statement that sets out the rules of the common hold and is binding on all unit owners. And through this rule book, the unit owners can be bound by positive covenants. So if we look at the two reasons why leasehold is used as the form of delivering ownership of flats, to enforce positive covenants and to provide a management scheme, those are removed and replaced in common hold. The common hold community statement enables the positive covenants to be enforced, and common hold itself provides a bespoke management scheme to enable blocks and estates to be managed. Now, common hold, as I said, was not new. It was introduced in England and Wales in 2002 in the Common Hold and Leasehold Reform Act. And common hold came into force in that act in 2004, but fewer than 20 have been created. Now, there are a number of reasons for that, including the fact that leasehold works in the financial interest of developers and landlords who choose what to build. So if you're a developer or a landlord and you've built a block of flats, you can either sell off the flats on a long leasehold basis, in which case you keep a financial asset and you keep the income streams, such as that enfranchisement premium that the leaseholder will pay in due course, or you can sell that flat as common hold, in which case you have no further financial interest in the flat. So it's easy to see that if you're a landlord or a developer, there are advantages to you in using leasehold. But there are also problems with the law that governs common hold. The legislation that we have that was introduced in 2002 is seen as being too inflexible and not really suited for the large mixed-use developments which are more commonly built today than they were when that legislation was developed. And so our project makes recommendations to update the law so that common hold can be used in place of leasehold. It is left for government to decide how it may incentivise common hold or even compel its use to take away, for example, the advantages that leasehold currently offers to landlords and developers. And so in making recommendations to reform the law, we've looked at a number of aspects of common hold. For example, we've looked at how to make the law more flexible so that individual parts of a single common hold can be self-managing. So, for example, we've made recommendations so that if there are two blocks on an estate, then each block could manage its interior on its own, but the two blocks could share the management of common facilities, such as a car park and gardens that they both enjoy the use of. We've also made recommendations to improve the experience of common hold owners, ensuring that they have a proper say in the budget that the common hold needs for its management and maintenance, and to protect their expectations if the rules in the common hold community statement are changed. And we've made recommendations to ensure that common holds are managed effectively and are financially robust, for example, ensuring that common holds have what are known as reserve funds, funds for major works that are paid over a long period of time so that when major works become due, the budget is there to complete them. We also put in place an effective scheme for making decisions when a block is at the end of its life and a common hold needs to be terminated. Now, we consider that common hold is preferable to leasehold as a means of delivering home ownership. It can fulfil the expectations of homeowners in a way that leasehold cannot. In terms of security, unit owners own the freehold. They own their unit, their flat, forever, in contrast to a lease. Common hold places autonomy and control in the hands of the unit owners through their membership of the Common Hold Association. And in common hold, there is no division of the financial value of the asset between the unit owners and a third party. There is no separate freehold asset. The value of the common parts is owned by the unit owners as members of the Common Hold Association. Well, I hope that in this short lecture, I've highlighted to you the impact that land law, real property, has on real people, and how a body of law that can appear technical and abstract can have a profound effect on people in relation to that most important piece of real property, their home. I hope I've demonstrated how law reform and the work of the Law Commission can play a significant role in improving how the law operates, and how our work on residential leasehold and commonhold can help to ensure that the law that governs home ownership is fit for purpose, and that the benefit of home ownership is enjoyed more fully in future by those who currently own their home on the long lease. Now, of course, the Law Commission publishing a report doesn't change the law, so government must now consider the recommendations for reform that we've made and bring forward legislation in order to make changes to the law. As you continue your studies, I'd encourage you to think at every stage in land law what impact the rules that you are studying has on those that they apply to. And so I want to encourage you to look behind the real property to the people. Well, thank you for listening to this lecture. If you want to read more about the work that we've done on leasehold and commonhold, or indeed any other projects we're doing that you're studying on your law degree, do have a look at our website. For our work on leasehold and commonhold, I'd really encourage you to read a summary of the reports that we publish called The Future of Home Ownership that will expand on some of the issues I've covered in this lecture. I do hope that you enjoy your studies in land law. Goodbye.